and welcome to this series talking about the consumer protection rights. So this is part 2 of the Consumer Protection Act 2019, and in this part we will be covering the aims and objectives of this act. Secondly, who is a consumer? And thirdly, what are the rights of a consumer that are given to him under this act? So first, let's get a small crisp understanding of what all subject matter that we have already covered. So firstly, we got to know in the first part about the historical journey of COPRA. COPRA here is the Consumer Protection Act in its short form. So we got to know that it has been a result of innumerous consumer movements all around the world. Then secondly, we understood the value of consumer, that what role does a consumer have and what actually is the value of that consumer, keeping in mind the economy of any nation. And thirdly, we got to know about the specific grievances of the consumers that they had to face and actually why did they ever make this demand of having consumer protection rights for themselves. So, beginning with the aims and objectives of this act, let's see that what all are the main agenda or the main aims that are covered under this act. So first of all, it is there to protect the interest of the consumers. So definitely, as the name itself suggests, it is the consumer protection rights. So the very aim of this act is to protect the interests, whatever the transactions that the consumer is making in the economy, it should be protected against any violation. And secondly, and most importantly, it provides for simple, speedy, and affordable redressal of consumer disputes. So actually, these three factors, being simple, speedy, and affordable, makes this Consumer Protection Act one of its kinds. And that is why it becomes so easy for the consumers to avail for compensation and justice under this act. Now, what provisions actually make it simple, speedy, and affordable, we will be understanding in the slides to come further. So this is a very small excerpt from the preamble of this act, which reads like, it says, the aim of this act is to provide for better protection of the interests of the consumers and for the purpose of making provision for the establishment of consumer councils and other authorities for the settlement of consumer disputes and for matters connected therewith. So these words highlighted in white color actually form the base of this act. So they say that we will be protecting the rights of the consumers. That definitely is the aim of this act. Secondly, it says that for this purpose, there will be establishment of consumer councils and other similar authorities for that matter. And finally, it says that these authorities and councils would be established for the settlement of consumer disputes whenever they arise in the matters connected therewith. So, now, when we would want to dwell deep into the Consumer Protection Act and its aims and objectives, it is very important for us to understand actually as to what all does this act apply to. So firstly, the goods. So everything that we can see and touch which is tangible in nature are the goods. So it is very convenient for us and easy for us to understand that yes, of course, we use these goods, and so any deficiency or discrepancy in these goods, if occurs, so we can definitely go and file a complaint under the Consumer Protection Act. So as also we can see in the figure, this shopping cart that this lady is holding has the refrigerator, the washing machine, the microwave, an ironing machine, a vacuum cleaner, and various other tangible goods that we can easily see and touch. So definitely, if any shortfall or any discrepancy occurs in these goods, we can go and file a complaint under the COPRA. But what needs to be made clear right here is that the purview of Consumer Protection Act is not only limited to the goods, but also extends to the services. Now, what do we really understand by services? Services basically are intangible in nature. We can't really touch them or see them as unlike the goods, but they are very, very important, just like the goods, and they serve a very important purpose in the society and the economy as well. So we can take small example like the housekeeping, the nursing, teaching, etc. They're all examples of services. Like for example, if you're booking a hotel through any app, or if you are using the applications like Make My Trip and other such portals for booking any services. These are all examples of services and will be counted under the Consumer Protection Act. So all such means or all such benefits that are provided or all such works that are done through such intangible things will be covered under services. Now, what next do we need to understand is that this Act of Consumer Protection Act covers not only the goods and services, but all the sectors. Now, it might seem a bit confusing to us right now as to what and which sectors are we talking about. So, in particular, it talks about the private sector, the public sector, and the cooperative sector, all in all. But for this, we also need to have a crisp understanding as to what do we actually mean by private, public, and cooperative sectors. So giving it a brief explanation, the private sector is simply the one which is owned either by an individual or by a group of individuals. So as we can see that only a single person has been depicted here. So either, as the name is also suggesting, this private sector, the companies under the private sector are owned by the individuals, only one person or a small group of individuals. Then the main aim of the private sector or the companies under private sector is profit making. Yes, definitely they will be providing some kinds of goods or services or both to the consumers. Only then obviously they are gaining the profit. But the main aim of private sector is to make profits for themselves first. And in order to do that, they provide the benefits and profits, goods and services to the consumers as well. But still, the primary aim would remain to make personal and private profits. So a good example of this can be considered as Reliance Industries. So the Reliance in India is providing huge amounts of goods and also a lot of services and various kinds of services to the consumers. But yet it will be counted under the private sector and is a private company. Now, jumping towards the public sector. So as the name again itself is giving us a hint that it is something that would be dealing for the greater benefit of the public at large, for the people at large. So yes, the public sector or the companies under the public sector are owned by the government. No any single individual or a group of individuals has a control over it. But the government is the sole owner of such companies or this sector. Then, obviously, the main aim of this sector would be non-profit and providing services. So the main aim here is not to make personal profit or gain, but to provide the basic goods or basic services to the people at large. A good example of this can be the BSNL. So the BSNL services or the Bharat Sanchar Nigam Limited services are owned by the government of India. Now, what can be the basic difference again between the private and public here is that many times there are some kinds of goods and services which are not very feasible for the private individuals to produce or to sell. There could be various reasons to it. Maybe they do not have the adequate resources to extract such goods and services, to produce such goods and services, or maybe it is not possible for them to make greater gains or profits from selling such goods or services. Now, at that point of time, here the government takes up this role of providing goods and services to the people. And since they are not aiming for making personal profit and for providing public benefit at large, they are the ones who deal with this. Now, finally, understanding the meaning of cooperative sector. So again, the name itself is giving us a good hint as to what would be the meaning and what would be the criteria for the cooperative sector. So if we get a small definition of cooperative sector, so it says that it is an autonomous association of persons united voluntarily to meet their common economic, social, and cultural needs and aspirations through a jointly owned and democratically controlled enterprise. So here, there were a few keywords that actually gave us the correct meaning of cooperative sector. First, it is an autonomous association, which means that it does not really have any superior body above it. Yes, obviously there would be norms of government which will have to be followed, but ultimately there is no any superior body to control each and every conduct of the cooperative sector. Secondly, the people in this sector must be united voluntarily. So they actually come up on their own to fulfill their own economic, social, or cultural aspirations. And thirdly, they have a joint ownership. So yes, no single person, not even a single person among such cooperative sector is the sole owner of the company or the sector to say, or the enterprise to say. The ownership is joint, and yes, the functioning, the entire control whereabouts are done democratically. So that is, if there is any company or anything running in such module, that would come under the cooperative sector. So for example, the PMC Bank, which is the Punjab and Maharashtra Cooperative Bank, which was recently in news for its financial crisis, is one of the examples of cooperative banks, so which comes under the cooperative sector. And another example of this is Apna Sehkari Bank Limited. So there are various other cooperative banks and cooperative bodies that run under the cooperative sector. Now, next thing which we need to understand here is that, and another factor that makes the Consumer Protection Act so nice and so readily available for the people and the consumers is that it works on the idea of providing mandatory compensation to the people. So it is very important. It is one of the very important provisions of the COPRA that it provides for mandatory compensation. So whatever the goods and services have been found as deficient, the producer now has to fulfill through the compensation such deficiency or such discrepancy in the goods or services. Now, here is a short question for you all. Which other law also, like the COPRA, focuses more on the compensation and less on penalty? So from the discussion that we have had till now, I'm sure that you would be able to conclude this answer. Anyway, we would be discussing the right answer at the end of this discussion today. Now, the next point talks about that it has a provision for consumer protection councils. Now, let's see that what all consumer protection councils do we have under this act. So first is the national CDRC, second is the state CDRC, and third is the district CDRC. Now, as we can clearly see here, that here is in some or the other way, a hierarchy can be seen here. Yes. So just like the judicial system in India, which works on a hierarchy basis, wherein we have the sessions and district courts, above which we have the high courts, and at the top we have the Supreme Court. Here as well, the CDRCs or the Consumer Dispute Redressal Commissions fall in line in a hierarchy. So at the base or at the lowermost level, we have the district CDRC. Above that, we have the state CDRC, and then we have the national CDRC. But what needs to be kept in mind here is that national CDRC is still not the highest body of appeal or the highest body here. The Supreme Court of India is the highest one. So ideally, it goes like district, then to state, then to national CDRC, and finally to the Supreme Court of India. Now, let's try to understand that what actually do we mean by consumer in the Consumer Protection Act. So Section 2 Clause 7 of the Consumer Protection Act 2019 deals with the definition of consumer. So it says, anyone who buys or agrees to buy any goods. So any person who has bought a good or has only agreed to bought a good. So what we need to keep in mind here is that a consumer would not only be a person who has already bought a good, but also the person who has agreed to buy a good, though he has not substantially bought it till now, but agreed to do so. For a consideration which has been paid and partly promised, or under any system of deferred payment. So the next thing that we need to keep in mind is that for such goods that we are talking about, some kind of the consideration has to be paid by the consumer. So consideration actually has not been defined under the Consumer Protection Act, but we would be considering the similar meaning, the same meaning of consideration as given under the Indian Contract Act 1872. So consideration has to be paid. Also, it says it could be partly paid and partly promised, that some amount of that consideration has been paid and some amount has been promised to be paid on some later date. And it could also be a situation where a deferred payment system, which means for the postponement system, which means on a future date also some consideration could be paid. So it is again not compulsory here that the entire amount or the entire, what would we say, the entire set of the consideration is paid here. It could be paid, partly paid, or also even it could be promised to be paid on some later date. But there has to be some consideration all in all. So it includes any user of goods, but there is an exception that the purchase of goods for commercial or resale purposes is not allowed, which means that if any purchase of goods has been made to cover or to do any sort of commercial or resale purpose, that would not be allowed, or that would not be counted as a consumer under the Consumer Protection Act. Now, we will be dealing with this commercial purpose in detail, since this actually forms one of the very important arguments of the definition of consumer or the consumer transactions under the COPRA. So now we've already understood this in keeping in mind the goods. And as we already know that the Consumer Protection Act extends not only to the goods but also to the services. So here a similar explanation has been given for the consumer, keeping in mind the services. So it says that anyone who hires or avails any services for a consideration which has been paid or partly paid and partly promised, or under any system of deferred payment, includes any beneficiary of services. So this simply is an example, is just the explanation or the definition of consumer, keeping in mind the services. So now we already know who actually is a consumer under section 2 clause 7 of Consumer Protection Act 2019. But now it is important for us to understand that what actually do we mean by commercial purpose that has been explicitly excluded from the definition of consumer under the Act. So it says that commercial purpose does not. So now here there is another exception to the meaning of commercial purpose. It says that commercial purpose does not include the use by a consumer of goods bought and used by him exclusively for the purpose of earning his livelihood by means of self-employment. So it says that if a particular good has been bought by a consumer and he is using that particular good exclusively for earning his livelihood, and that particular good is the sole source of his livelihood, and he is self-employing himself, he himself has employed himself in that good, that transaction would not be called as commercial purpose, and thus that person would be counted as a consumer under this Act. We will further understand this with an example, and we should know that this concept of commercial purpose was not since the beginning of the Consumer Protection Act 1986, but it was inserted by an amendment of 1993. And this entire thing, or this entire idea, or this entire explanation was given in the case of Dinesh Bhagat versus Bajaj Auto Limited, 1992, CPJ 272. Now, let's understand this entire concept with this example. So here is this person A who buys a truck for himself, for his own livelihood. So these words have to be kept in mind, that he bought the truck for himself first of all, and secondly, it was the only thing that served his livelihood, and that was the only means of his livelihood. So this will not be a commercial purpose, and thus A will be counted as a consumer under the Consumer Protection Act. Now, moving towards the next situation, where this person A came in contact with another person B, and he gave his truck on rent to B. Now, since A is not using it for his own employment, so he is not self-employing himself, and he is giving it on rent and availing the commercial value of that truck. So that becomes an example of commercial use, and he will not be considered as a consumer under the Consumer Protection Act. Now, let's consider another small example for this purpose. For example, I have a shop in the market, and that is located in a very good place in the market. And now I was using that shop for my own use. I was selling the products or using it for anything, but I was using it on my own for my own livelihood. Now here, I give that shop on rent to somebody, and that rent is is one of the value. It is a piece of the market value of that shop. I'm trying to actually exploit the commercial value of my shop. So that will be an example of commercial use. So whenever, keeping in mind the Consumer Protection Act, if a person tries to exploit or gain from the commercial value of a particular good, that will be counted under the commercial purpose. And at that very moment, that person, like for an example, this person A earlier was a consumer, but now from the time he gave this truck on rent to somebody else and he decided to make the commercial benefit out of his own good, he will now not be counted as a consumer under the COPRA, and this will be counted as a commercial purpose for this matter. Now, here is another question for you all. Under the same understanding, can a student taking exams against a fees paid for the exam be considered as a consumer under COPRA? Just think and answer. We will be dealing with this answer also in the end of the discussion. Now, let's understand that what are the rights that are granted to the consumer under the Consumer Protection Act 2019. So first, it says right to protection. So against what are we claiming the protection, or against what are we given the protection? So it is against the marketing of goods and services that are hazardous to life and property. So if in case there is any goods or services that are found to be hazardous or dangerous for the life or property of the consumer, that shall be banned then and there, or some regulation shall be brought against that goods or services. Secondly, it says right to information. So information about the quality, the quantity, standard, and price of goods and services. So definitely, if we are to make judicious use, and if we are to make any particular use of goods or services, it is important as being the consumers to understand about the quality of the goods, the quantity of the goods, the quality of the services as well, and the standard and prices of such goods and services. So next, it talks about right to be heard. Definitely, if all the provisions are there and nobody is there to hear the grievances of the consumers, there is no point having such an act. So definitely, it provides us with the right to be heard. Next, right to seek redressal. And definitely for that purpose, we have the various consumer redressal forums and councils at various levels. And finally, it talks about the right to consumer education. So one thing that is important in this is that the aim of Consumer Protection Act is not only to protect the consumers once the harm is done, but it is also important from this edge to understand that it is very necessary for the government and various other authorities to educate the consumers about the unfair trade practices and other kinds of malpractices going on in the market. For example, the Jago Grahak Jago campaign, which was very readily taken up by the government of India, is one such example. So it was an initiative to make the people understand about the various malpractices that take place in the market, and so that the consumer should be aware beforehand as well. Now, let's discuss the answers to my questions that I had asked in this slides. So another law that talks about compensation above the punitive nature is the law of torts, and that is why many a times Consumer Protection Act is studied under the purview of law of torts itself. So the law of torts is more compensatory in nature and less punitive. And second, an examinee is not a consumer. So it was in this case of Bihar School Examination Board versus Suresh Prasad Sinha, AIR 2010, that the Supreme Court held that the school examination board was not a service provider and the student taking the exam was not a consumer under this act. The court also said that the fees which was given by the student as the examination fees cannot be considered as a consideration, and hence this entire activity cannot be taken up as a service, and thus the student will not be considered as, or the examinee will not be considered as, a consumer. Now, let's discuss some potential questions from the prelims point of view. First, choose the correct statement or statements about the Consumer Protection Act. First, it includes both goods and services. And second, it includes only public and private sector and not the cooperative sector. Second, Which of the following rights is not guaranteed under Consumer Protection Act? First, right to redressal. Second, right to commercial use of goods. Third, right to be heard. And fourth, right to information. Now, let's see a question from the mains point of view. With the enactment and implementation of Consumer Protection Act 1986, a new consumer jurisprudence has developed in India. Elaborate. So this question has already been asked in the UPSC Civil Services Exam Mains 2011. And this also has brought the entire concept of Consumer Protection Act in the discussion. So with this, we hope that it was an informative session for you, and we will be talking about Consumer Protection Act in our further lessons to come. Stay tuned with us, and thank you.